Hi everyone, this is Shivani again, and today we are going to be talking about the doctrine of pith and substance in the Constitution of India. The Constitution of India has divided the extent of the powers of the legislature between the center and state by way of the seventh schedule under Constitution of India. The seventh schedule, what does it do? It specifies the subject matters and divides the powers of the powers to make the laws between the center and the state through by way of lists. There are three main lists that are present in the Constitution of India that divides the powers conferred upon by the legislature towards the center as well as the state. The first list is the Union List, List 1 or the Union List, which contains matter where the center has the power to make laws. Example, defense or foreign affairs. List 2 or the State List contains a subject where the state has the power to make laws. Example, public order, health, sanitization, etc. List 3 or the concurrent list contains subjects where both the center as well as the state have the powers to legislate or make laws. Example, forest, administration of justice, education. Although their spheres of influences are well established in the seventh schedule, there often arises a conflict as to whether the center should gain more power or the state should gain more power, as the case may be, or is encroaching upon the sphere of each other. To deal with these conflicts, the courts of India have evolved a few doctrines, and one of those doctrines is the doctrine of pith and substance. Pith means an essence of something, and substance means an essential part of something. So, how did the doctrine of pith and origin come into existence? Pith and substance origin, basically. It is widely believed that the doctrine of pith and substance originally came from Canada, and it was introduced in the case named Cushing versus Dubois in the year 1880. The doctrine later made its way into India and is firmly supported by Article 246 of the Constitution and the 7th Schedule. In India, it has evolved to become a celebrated doctrine that became the basis of many landmark Supreme Court judgments. This doctrine determines the difference, the encroachment of one of these powers, that is the state power, state legislatures, encroaching upon the union or the union encroaching upon the states. So, what is the doctrine of pith and substance? The doctrine of pith and substance states that within their respective spheres, the state and the union legislatures are made supreme. They should not encroach upon the sphere demarcated for the other. However, if among one of the state and the center does encroach upon the sphere of the other, the courts will apply the doctrine of pith and substance, that is, determination of the essence or the essential of that substance. If the pith and substance, that is, the true object and true intent of the legislation, pertains to a subject within the competence of the legislature that enacted it, then it would be held to be intra vires, although it may accidentally encroach on the matter not within the competence of the legislature. In one of the landmark cases through which the doctrine of pith and substance that came into existence, that is Praful Kumar Mukherjee versus Bank of Khulna, the Privy Council, back in the day when Privy Council was a part of India, the Privy Council applied this doctrine and stated that in this case, the Bengal Money Lenders Act of 1946 had been enacted by the state legislature, was challenged with the contention that the parts of the legislature dealt with promissory notes. Now, promissory notes had been a part of the central government. It was a part of the central list. Now, in this case, the Privy Council, while upholding the validity of the impugned legislation, stated that the Bengal Moneylenders Act was in pith and substance, that is, in essence, essentially related a law which was related to money lenders and for the purpose of money lending. Money lenders and money lending at that period of time was a state subject, even though it accidentally trenches upon the promissory note part, which was a central subject. But that the essence of the Bombay Bengal Money Lenders Act in pith and substance was actually a part of the state legislature. Therefore, even though it encroaches accidentally upon the promissory note part, which is a part of the central government, in such a case also the act is said to be held as intra vires, which means it is upheld and is valid. In the case of State of Bombay versus F.N. Balsara, the Bombay Prohibition Act was challenged on the ground that it accidentally encroaches upon the import and export of liquor across customs frontier. Now, this was a part of the central subject. The court, while upholding the impugned legislation, declared that the act was in pith and substance a state subject, even though it accidentally encroached upon the central subject. What is the doctrine of territorial nexus? The doctrine of territorial nexus states that laws made by the legislature are not applicable outside the state. It is only applicable when there is sufficient nexus between the state and the object. Among the pith and substance, it is important to determine the doctrine of territorial nexus, which means how much boundary does the legislature have within itself while creating a legislature so that it does not encroach the other legislature. It is invoked, this doctrine is invoked in the following instances. There are two instances where this doctrine invokes. First, whether a particular state has extraterritorial operation. Second, if there is a territorial nexus between the subject matter of the act and the state making the law. The doctrine of territorial nexus signifies that the object to which the law applies need not be physically located within the territorial boundaries of the state. Instead, it should have sufficient territorial connections with the state. The state can levy a tax on a person, on an object, or any transaction not only when it's situated within the territorial limits, but also when it has sufficient and real territorial connection with it. What are the important with this, we are going to move on to the important ingredients that constitute the doctrine of pith and substance. The first one is this doctrine is applied when the subject matter of list 1 of the 7th schedule is in conflict with the subject matter of list 2. Why are we not including list 3 in this? This is because of the entire reason that list 3 confers powers to both the state as well as the center to determine legislation. However, only when the matters of list 1 and list 2 are in conflict with each other, then this doctrine of pith and substance comes into existence. The reason behind adopting this doctrine is that otherwise, every law will be declared invalid on the ground that it encroaches upon the subject matter of another sphere, because it is physically impossible for one law to not be connected with another law or not encroach another list accidentally or incidentally, where it has to determine the cause of the existence of that particular law. The doctrine examines the true nature and substance of the legislation in order to determine which list it belongs to. It takes into consideration whether the state has the power to make that law that encroaches on a subject matter from another list. The doctrine was first applied and upheld by the Supreme Court in the case of S.N. Balsara case that we had previously discussed. The doctrine of pith and substance has provided the Indian constitutional scheme with much needed flexibility, because if there is no flexibility within the ambits of Indian constitution, making it rigid would only limit the scope of the constitution, would only limit the scope of the judiciary or the executive and the legislature in order to make the laws, and in such a case, the limitation of which would cause disharmony amongst the pillars of the Indian democracy. Because in the absence of this doctrine, every other law would have been declared invalid because it incidentally encroaches upon the sphere of another legislature. Apart from this applicability in cases related to the competency of legislature as mentioned under Article 246, the doctrine of pith and substance is also applied in cases related to Article 254. What does Article 254 deal with? It deals with the repugnancy of laws made by Parliament and laws made by the state legislature. Even in those cases when the laws made by Parliament and the laws made by state legislature encroach upon each other incidentally, then also the doctrine of pith and substance comes into existence to determine whether or not such a legislature really encroaches upon the state or the central legislature, or whether it is something that can function independently without the encroachment of such. The doctrine is employed in such cases to resolve the inconsistency between laws made by the center and the state legislature. We come to conclusion. Um, Despite the vivid segregation of powers between the center and the state, it is quite inevitable that the ancillary encroachments are bound to take place during the enactment of the laws. Therefore, in order to tackle such, the powers demarcated as per Section 100 of the Government of India Act 1935 was so rigid and so stringent that it gave no scope to the application of doctrine of pith and substance. Therefore, subsequent to the framing of the Indian Constitution in 1949, when such incidental encroachment of the legislative power takes place, the judicial review or the power of the judiciary comes into picture, where the courts, with the aid of the doctrine of pith and substance, decide the validity and legitimacy of such an enactment and whether such encroachment was really necessary or not. So, summing up, the basic purpose of doctrine of pith and substance is that it places an emphasis on the fact that it is the real subject matter which is to be challenged, and it is not incidental effect on another field. Pith denotes the essence of something or the true nature, while substance states that most significant or essential part of something. So, the doctrine of pith and substance means the true nature of law. The real subject matter is challenged and not its incidental effect on other field. This is because if it affects the other field, then it would definitely be termed as encroachment. But determining the real essence of the law that came into existence for which it is to be encroached, the doctrine has to be applied. The doctrine is applied in India also to provide the degree of flexibility in the otherwise rigid system of the distribution of powers. So with that, we end the topic of doctrine of pith and substance.